foreign element guides, or how foreign element is an important or central criteria of identifying a private international law dispute. So that's the first lesson of the last lecture. The second broader lesson from the last lecture would be that every private international law dispute would involve almost three different stages. The first stage would be the question of jurisdiction, that whether a particular judicial body within the municipal legal system has jurisdiction to try that case or not, to look into that case or not. The second would be choice of law, which broadly means, and we are going to talk about all these three elements throughout the semester. Right after the next 2 or 3 lectures, I'll pick all these concepts and we will talk about it in detail. But at least at this stage of time, you need to know that every private international dispute will involve these three stages: the question of jurisdiction, the question of choice of law. What do I mean by choice of law? By choice of law, I mean that which law is going to apply in a given situation, whether the Indian law would apply or whether a foreign law would apply. The last is the question of recognition and enforcement of foreign judgments and awards. Now just imagine that a foreign municipal court has come out with a judgment which needs to be enforced in India. What is the process? First, it has to be recognized and then the enforcement happens. So these are the three stages which are involved in almost all private international law dispute. So that's the second lesson from the last lecture. The third lesson from the last lecture is with regard to the definition of private international law. So in the last lecture, we tried to define as to what we really mean by private international law. And we picked up Cheshire's book to see how he has tried to define the term private international law and what he really means by private international law. Now, why did we pick Cheshire's definition? Because this is one of the most recognized definitions of private international law, and you can find the reference to this definition at multiple places in almost every textbook on private international law. What were the 4 elements of definition which we studied in the last lecture? The first was that when Cheshire says that private international law is that part of law, and in explaining this concept of that part of law, we concluded that that part of law broadly implies the municipal law of a given country. The second element of Cheshire's definition was that which comes into play when the issue before court affects some fact, event, or transaction. In terms of explaining this part, we concluded that fundamentally we are talking about private matters or private law disputes and not public law disputes. We also saw the distinction between these two kinds of disputes. The third element of definition which we studied in the last class was that when Cheshire says that when these facts, event or transaction are so closely connected with a foreign system of law. And we saw that by this phrase, closely connected with a foreign system of law, Cheshire means foreign element or the presence of foreign element in a dispute. And the last element which we studied as part of the definition of private international law was to necessitate recourse to that system. Now, in this last quality or criteria of private international law as propounded or as defined by Cheshire, we see that because of the presence of foreign element, it becomes necessary to apply a foreign law altogether in relation to that dispute. Now, these are the 4 fundamental elements emerging from Cheshire's definition. As I did the last time, I am pasting it again in the chat box for your convenience. So this is the definition which we spent almost half an hour in the last class. So please have a look. So fundamentally, that is how I'm going to revise the last class. So these are the 3 major takeaways from the last lecture. Now we move ahead with our discussion on private international law. The next topic for our discussion in this course is that what are the reasons for private international law? Why do we need a subject called private international law? What's the point of applying foreign law to a dispute which is before a municipal court, there must be some logic, there must be some larger justification to it. Now, in today's discussion, we are going to understand the basis of private international law. We are going to understand the reason for private international law, as to why private international law as a subject exists, as to why we study private international law. Right? Now, before I move, I'm just thinking, why is it important to identify the reason? I mean, why is this question even important? That one must have a reason for private international law. If it is a law, it is a law, like any other law. You have Indian Penal Code. You hardly ever get into the debate as to why there is something called Indian Penal Code, and if at all it is there, whether the reasons are justified or unjustified. Now, that has to be done as a matter of policy. We can do it even in terms of how our municipal laws are placed, IPC being one, tax law being another. You can do it for contract, and you can do it for all other laws, and understand the reason as to why this law is placed in the society. There must be some reason as to why within Indian legal system we have law of contract. Now, while these questions are important for all the laws, this question is fundamentally important for private international. Why is it important for private international law? Because for other laws which you have, Indian Penal Code, law of tort, or for example, law of contract, or pick up any domestic law for that matter, the fundamental basis or the fundamental legitimacy of those laws are to be found in Indian legal system itself. So you are sure that Indian Parliament has passed what is today known as Indian Penal Code. It is a valid law in accordance with how the supreme law of this country is placed, that is the Constitution. But when it comes to private international law, the problem gets serious, because in private international law matters, it is a foreign law that we are fundamentally dealing with. Because it involves that element of application of foreign law, therefore this problem gets further exacerbated. Say that now, why are we applying foreign law when that law has not been passed by the parliament of this country? When that law has no basis within the municipal legal system of this country, that is the Indian legal system, or for that matter, any other legal system we are concerned with. It could be UK legal system, US legal system, Sri Lankan legal system, Nepalese legal system, it could be any legal system for that matter. Now, it is for this reason this question becomes very important. Further, this question is significantly linked to the idea of sovereignty, because each and every state is sovereign within their own sphere. Each and every state is autonomous within their own sphere, meaning thereby, by sovereignty, fundamentally we mean that state cannot be pushed, or that state cannot be forced to act in a particular way within their municipal order or in their external relations. So that state takes its own decision. The moment a state is guided by, or the state is forced by some other external force to take a decision, whether internal or external, in a formal sense, that would imply that that particular state is a non-sovereign state. Now, we have a classic example of how sovereignty can be extremely crucial in determining the legal status of a territory. Colonialism is a fantastic example. That when many countries of Asia and Africa were colonized, what they really lacked was sovereignty, where an external force, the colonial master, was guiding the internal and external relations of the country. They had significant control over the internal and external affairs of the colonized territory. And once you become sovereign, you get right to make your own laws. You get right to reject the laws of the foreign country. You say that foreign laws don't apply here. It is our laws which would apply. And this is another aspect as to why the reason for private international law, or finding the reason for private international law rather, becomes even more important. And this is precisely what we are going to do today. Therefore, to summarize the first part of today's lecture, is that private international law, because it envisages, say, a possibility of applying foreign law or law of other country, it becomes important to identify the reason for private international. Before I move to identify specific reasons, let me use the next 1 minute to define foreign law. We need to understand as to what we really mean by foreign law, because we have been using this term again and again. In the last class, we tried to understand what we mean by foreign element. Today, we are going to understand what we mean by foreign law. To put it in very simple sense for your convenience, if you don't understand, please let me know. That foreign law would be, say, a law which is different from the system of law, which the court will apply to a purely domestic dispute. Now, if say there is a contractual dispute before an Indian court, and as a matter of general practice, the court would apply Indian Contract Act to that particular dispute. Now, that is an Indian law, or what is also known as internal law, which applies to the dispute. But just imagine a situation that the same contractual dispute involves, say, a foreign element, which necessitates, as per the definition of Cheshire and how he has tried to define private international law, that necessitates the application of foreign law by an Indian court. Now, in such a scenario, that application of a law which is different from internal law or Indian law is how we identify foreign law. So, foreign law is a law which is different from the law which the forum court is supposed to apply in a general matter, to put it more simply. I hope this part is clear. Is this part clear, yes or no? Or any questions here? Okay. If you have any questions, let me know. Any doubts, any questions? No, nothing. Fine. Then we move to identifying the reasons of private international law. Now, the reading which I have circulated to you, if you have gone through the reading, Cheshire identifies two fundamental reasons for private international. There could be many reasons, but these two are, say, relatively more rational way of looking into as to why we need private international. The first reason which Cheshire identifies is that he says that if we don't apply foreign law in matters involving foreign element or in disputes involving foreign element, that would lead to gross injustice. Now, how is that going to happen? And let me explain this point with the help of an example. Now, just imagine that a couple got married in accordance with foreign law in, say, 2010. And right after their marriage, they shifted to another country, say India. They got married in, say, Germany, and they came to India. They have been living in India for the past 10 years, and while they are German citizens, their domicile is Indian in legal sense. Now, just imagine that there is a matrimonial dispute between the couple and the matter reaches Indian court somehow. Now, the problem is that if we totally neglect German law and we apply Indian matrimonial laws to the couple, there might be certain specific conditions of marriage which was present in German law but absent in Indian law. So while the marriage would be valid in German law and their marriage is validated under the German law, the same marriage might not satisfy all the criteria of Indian law. So if Indian courts mechanically apply Indian law to check the validity of marriage, it might lead to a scenario where marriage is, say, valid in one legal system, that is the German legal system, and invalid in Indian legal system. Now, it is for this reason that Cheshire cautions us He caution he argues that mechanical application or invariable application of law of the forum, and this is a term which you are going to come across quite often, law of the forum, or which is also known as lex fori. When we say law of the forum or lex fori, what we mean is the local law of the place where the court is situated. Right? So if we are talking about Indian code, then law of the forum would be Indian law. Right? So Cheshire, in identifying the reasons for recognition of foreign law, first he argues that it might lead to gross injustice. And the injustice is precisely this, that as I tried to demonstrate with the help of this example, that the marriage might be valid in one legal system and might be completely invalid in another legal system. So a marriage which is justified, which is legal, which satisfies all the criteria of German legal system, the same criteria or the same marriage might not satisfy all the criteria of, say, Indian legal system, because the conditions of marriage in these two legal systems might be completely different. It is for this reason Cheshire says that it requires the application of foreign law in matters involving or in disputes involving foreign element. The second reason which Cheshire identifies in terms of talking about the reasons for recognition of foreign law in matters or disputes involving foreign element is that if we invariably or if we mechanically apply Indian law or, for example, municipal law to a dispute involving foreign element or dispute having foreign element, then it might also change or ignore the legal position under which a particular act was performed. Now, let me give you another example to simplify this proposition by Cheshire. Now, just imagine that two Indians, they travel to Germany. They are engaged in a business. They go to Germany and they enter into contract. And when they enter into contract in accordance with German law. Now, German law might have specific conditions for the validity of contract, which could be valid under, say, German law. Then they travel to India and they have some dispute and the matter reaches Indian courts. Now, the fundamental issue is that Indian court, if they apply Indian law, then they might find the contract to work in a significantly different way than how contract would have worked if German law was applied. So the two Indians who traveled to Germany to enter into contractual relationship because they were involved in a business in Germany, when they entered into the contract, they were extremely clear in their head. Their intent was very, very clear that if at all a dispute arises in relation to, say, this contractual obligation, then German law would solve the dispute. Right? And let's also add another element to it. They were also clear about the fact that if there is a breach of contract, then say 5,000 euros would be given as compensation if we apply German law. Now, if Indian courts in relation to a dispute between these two individuals applies Indian law, the danger is that that it will invariably change their legal position or what was. So legitimate expectation of parties is something which is central to any legal system, and application of foreign law in a dispute involving foreign element preserves legitimate expectation. I hope both these 2 points are clear to you, what Cheshire is trying to make. I think I've spent time on that. If there are any questions, please ask. Now, another reason which is often given, in fact, this is one of the most central reasons identified for the basis of private international law. And this reason is known as Comity of Nations. What do we mean by Comity of Nations? Nothing but relationship between nations. Relationship in the sense that we have respect for other nation or friendliness between the nations of this world. Now, comity of nation is often identified as one of the reasons for private international law. He said that because states respect each other, and this respect is reciprocal in the sense that all states of the world respect each other in their mutual existence because they are sovereigns. They have a particular legal quality. So all the nations of the world have a particular legal quality, and they are defined in terms of how sovereignty is central to all these nations. And therefore, comity of nation is considered as one of the main bases of private international law. That because they respect each other, they are fine with the idea of applying foreign law in matters involving foreign element so that injustice does not happen, as I just explained 5 minutes back. Or, for example, the legal position of the parties do not change, as I just explained a minute back. Now, this is the third reason which we can broadly identify for private international law. However, when you look at Cheshire, and why am I referring to Cheshire? Because that's almost acceptable that this is one of the most recognized books on private international law, and almost every other textbook or literature which you will come across or you will read, you will find mention of Cheshire. Its acceptability is beyond doubt, and perhaps the most central book which we have in terms of studying private international law. Of course, in order to study Indian practice on private international law, we might have to refer to few other textbooks like that of V.C. Govindraj and others, which we will do. But for introduction at least, and for other conceptual topics, we cannot ignore Cheshire. As students of private international law, we must start our discussion or fundamentally go through Cheshire first. Then, of course, we can open discussion in relation to other areas and other literature which is there. And the reading which I have circulated is from Cheshire's book. So kindly go through that reading. That's a very important literature. Now, as I said, the third reason which I identified is comity of nation. Now, Cheshire is critical of comity of nation being identified as the basis or as the reason for the existence of private international. He says that it's not very convincing to argue, as per Cheshire, that comity of nation could be the basis of private international law. Now, why is that? The author has a problem with the idea of comity of nation, mainly because of three reasons. The first reason which Cheshire identifies in terms of having problem with the idea of comity of nation is that the word or the term comity of nation is a meaningless or misleading term, or it is employed in a meaningless or misleading way. This is a very important observation because among legal theorists, and particularly international legal theorists I can speak of because I often go through those literature, is this concept is known as the concept of indeterminacy. What do we mean by indeterminacy? What we mean by indeterminacy is that words may have different meanings, that the meaning of the word is not clear and it is susceptible to multiple interpretations. Cheshire is trying to put the same idea in a different way when he says that the phrase comity of nation is often employed in meaningless and misleading way. And he says that if something is employed in a meaningless and misleading way, how can it be basis of a normative space like that of private international law? So we cannot justify an entire gamut of laws, an entire web of laws known as private international law, through a loose term, a meaningless term, which is often employed in a misleading way, known as comity of nations. So that's the first reason which Cheshire identifies. The second reason which Cheshire identifies is that even if we are using comity of nations, it says that comity of nation implies relationship between states, respect for the state. He says that respect for state, relationship between nations is a policy question. It is not a judicial question. And he says that since private international law is a judicial act, therefore, Committee of Nations does not provide a viable explanation for private international law. He says that it might be a political act to engage or to respect this principle of Committee of Nations or this concept of Committee of Nations. But it is a loose exercise to argue that judiciary is supposed to engage in this task of Committee of Nations. That's another point which he makes. I hope you are following it because it has been a one-sided exercise. So I'm unsure if you are able to listen to me clearly, if everything is all right, if you are understanding the concepts well. If you face any problem, let me know. All right. So I hope everything is fine. And I hope I'm not hoping too much. All right. Now, the third reason which Cheshire identifies in terms of disagreeing with the point that Committee of Nations is one of the reasons for private international law is that the application of a foreign law does not mean sacrifice with sovereignty. He says that he fundamentally argues that it is not because of Committee of Nations that we apply foreign law in a dispute involving foreign element. We apply foreign law in a dispute involving foreign element because of the desire to do justice and not to respect other nations. He says that because if we don't apply foreign law, it might lead to a scenario where an injustice is committed to an individual because that person got, for example, the illustration which I presented in relation to the couple who got married in, say, Germany and their marriage was valid, but when they came to India and when Indian law applied to the same marriage, it was invalid. So this is precisely what Cheshire is saying, that it is not because of the relationship between the two countries that courts acknowledge the presence of foreign law or court acknowledge the importance of foreign law in application to a dispute having foreign element, but because of the necessity to do justice, because of the aspiration, because of the desire to do justice, that they apply foreign law. And they say that therefore we need to make this distinction in relation to private international law. Now, this is something which is very important and a point which must be emphasized here. Yeah. Any questions?
No, sir. Just that, yes, I was thinking the same thing that Committee of Nations, respect between nations, it can be something which can propagate the cause of private international law, forward it, but it cannot be a basis of why we are applying a foreign law or why we are studying this private international.
Okay, fine. So you agree with Cheshire in terms of how he is critical of, or how he is not very fond of finding Committee of Nations as a basis of private international law.
Yes, sir, exactly.
Okay, fine. I mean, yeah, even to me it sounds reasonable, and I have some other reason for not falling in that trap of indeterminate terms. But I would broadly agree with Cheshire and with you, of course. There's one point which I wanted to make at this point at this stage of time, and that's that when these countries are applying foreign law in a dispute involving foreign element, they are not discounting their sovereignty, or they are not compromising with their sovereignty. Because as I said, what do we mean when we say that a country is a sovereign? When we say that a country is a sovereign, that would mean that that country has complete internal and external autonomy. That country has complete power to guide its internal relations and guide its external relations. When that legal system or that country start applying foreign law in the domestic legal system, there could be an argument that this is discounting of or disintegration of the idea of sovereignty. However, this argument would be too far-fetched. That is not true, because when that country or a particular legal system is applying foreign law, that particular country or that legal system is not considering other laws as superior. It is applying foreign law as a matter of convenience to do justice, and not as a matter of conviction that the other law, the foreign law, is superior to that of the municipal law or the law of the forum. Please make that distinction, because yesterday in the other section this argument was made, and therefore I thought I should clarify this point. Often there is an argument, or that argument could be made, that in a sovereign country, if a foreign law is being applied, then don't you think it is discounting of or disintegration of the idea of sovereignty? But one need to understand that application of foreign law happens in private international law disputes mainly because of the desire to do justice, and not because one legal system considers the other legal system as superior to it. So a small legal system like Bhutanese legal system or Maldivian legal system is as autonomous as US legal system. In pure legal sense, the legitimacy of all these legal systems reside in their constitution. And because all these legal systems are sovereign, in legal terms they are equal. So it does not matter how powerful an economy is, how powerful military a country might hold. What matters is that whether they are sovereign or not, whether they are autonomous or not. So it is in this sense, please don't get confused between these aspects, that the moment we apply foreign law, we are discounting the sovereignty. That's not the case. Fine. Now, these are few reasons, these are three major reasons which Cheshire identifies. Now, let me briefly run through this idea that, now, so the reasons part are fundamentally done as to what are the reasons for the recognition of foreign law in matters involving foreign element. Now, this brings me to another issue, a rather simple issue with profound consequences. And this issue is that what is the nature of private international law? And there could be multiple ways of answering it, but at least one point which I want to make here is that private international law manipulates with the idea of space and time. This is something which you must remember while studying private international. Let me explain this point to you. What do I mean by the statement that private international law manipulates with the idea of space and time? When I say that private international law manipulates or maybe works around with space and time, what I mean to say is that it crosses the conventional idea, or it defeats the conventional idea that laws have a particular territorial application. So the laws of India in general cases apply to, say, the entire territory of India, or a ship having Indian flag, or an Indian or an Indian plane, for example. Now, that is the general idea of how territorial and extraterritorial application of laws really happen. Private international law manipulates with this conception. Private international law might also apply in a situation which is beyond the imagination of how a law applies to a purely domestic matter. Let me give you an example. Just imagine that a UK citizen holds the domicile of Germany, right? And then at the end of his life, he comes back to UK. And when he passes away, it is realized that he has left certain property in Germany. He also has property in UK. Now, a UK court is troubled by this question as to which law would apply in terms of distributing his UK property. Now, you might say that a UK citizen leaving certain property in UK before he dies. So leaving, there are certain properties in his name. Now he is dead. How will that property be transferred to his successors? Now this question should not be tricky. He said that if he is a UK citizen, just apply UK law and give the property to the people whoever is supposed to get it as per the UK law. But just imagine that UK law says that the law of domicile would apply in terms of determining the successor to movable property. Now a UK court is trying to determine the question of a question of the status of property of a deceased person who was a UK citizen. The property is also in UK, both movable and immovable. And when UK court looks into their own laws, say that fine, for immovable property, things are relatively simpler. Wherever the property resides, so if it is a land and the land is in UK, then the law of UK would apply. That's known as law of lex situs, and we will talk about it in detail when we go to these specific aspects. But imagine UK law says that for movable law, the law of domicile of the deceased person would apply. For movable property, the law of domicile of the deceased person would apply. Now UK court says this person was a UK citizen, but his domicile is not that of UK. His domicile is that of Germany. Now UK court is forced to apply German law in relation to transfer of, or in relation to the question of succession of his property. Now that is how private international law manipulates with space and time. That is how one is not confined by the conceptual peripheries or the conventional peripheries of the application of law. That, you know what, if it is an Indian territory, apply just Indian law and the matter is done away with. That is not the case. That is not the case when we talk about private international law. It has tremendous capacity to manipulate with the idea of space and time. When a matter involves foreign element, you are never sure which law might apply to that given scenario. It could be an Indian law, it could also be a foreign law. So one is never sure that just because the laws of a particular country is looking into the dispute, that the laws of that country, that the lex fori, the law of the forum, would apply in a dispute. This is something which you must remember. Now the second point which I made while making that statement, that private international law manipulates with space and time, or works around with space and time, or significantly affects space and time. Let's talk about time now. Now when we are talking about time, let's take an example. Now in the dimension of space for the matter, just imagine that the rights of a husband and wife towards each other, say movable property, are usually governed by the law of the domicile. That's the general practice. But does this rule of selection, or does this rule of domicile, which I just referred to, identifies domicile at the time of marriage or to domicile as it may change from time to time? So this is a very, very important point, and something which you might find technical at this stage. But when we read cases from the next unit, that is module, you will understand as to what I'm really trying to project here. So to put it simply, in the first example we saw that say how the movable property is to be governed, and the succession of movable property is to happen, that is often governed by law of domicile. As to what was the domicile of the person, the status of whose property we are trying to determine. But it also needs to be seen as to at what point of time the domicile of that person was, say, a German domicile or an Indian domicile, or for example a Canadian domicile. So both space and time are central criteria in determining or in understanding a private international law matter. Did you understand this point? Because this is a bit technical point, and I'm sure this would get further clear. But if you have any doubts, please ask. No questions. All right. Okay. Fine. But are you sure? I mean, I'm the only one speaking here, so I'm a bit confused. If you have any questions, please ask. Otherwise, this entire exercise is futile. The idea is to understand. The idea is not to complete 1 hour. We can do it very quickly as well, and that's why I'm repeating the points again and again, realizing that private international law is considered as a technical paper. No questions. I'm a bit surprised, but that's perfectly fine. Maybe I will not push you all to an extent where you say that maybe we have covered too much. We have another class today. I think, when is that class scheduled?
1:30, sir.
Okay. Okay. 1:30. Fine. We meet at 1:30 again. Fine. We will continue the discussion further. Yes, please.
Sir, I had a small request from everyone concerned.
Yeah.
If and only if it's convenient for everyone, can we consider moving the 1:30 lecture
To when?
to to a time slot that we have free tomorrow, Saturdays?
Generally, tomorrow I don't have any lecture schedule, and I would like to keep at least one day for me to study for the next week. So I generally spend Saturdays for my own work and Sundays to prepare for the week's lecture. So, if it is possible, can we leave it? Because it becomes too hectic. I hope you understand. Reading international trade law, private, and then I'm also asked to teach legal philosophy, which of course I voluntarily did, realizing that the paper was very interesting. But if we can avoid Saturday, I'll be happy. But if you really insist, I might try.
I'm in no position to insist. Just that I had all the classes managed. Just this one class is I'm not able to manage with any of the sections.
Okay. So Shubham, in your case, what I'm thinking is that the same day when we had lecture, you can talk to me. We can have a separate session on the same day in the evening, and I will try to explain the points which we have covered. So I was just thinking about it when you dropped those texts, that how can we really manage it? Because it's not just about the lecture; it's also about the conversation which we can have. And this goes for all the students. So I'm fine with the idea of, say, revising the lecture to you on days when you miss the lecture because of some other lecture. So just let the lecture. And I'm fine with the idea of sitting for another 20 to 30 minutes and then revising what we covered that day.
Okay, no problem, sir. This is the only lecture in the week where I'll need your 10 or 15 extra minutes.
No problem. You can just let me know. We can sit and have a discussion on it, because the conversation really helps. If it is a unilateral exercise from my side, it doesn't excite me much. I get bored at times. And speaking to a machine is not a very easy idea, let me tell you. Just give me 1 minute. Someone is at the door. Just give me 1 minute.
Sure.
Yeah. So we meet at. Okay. So you want to